Yesterday, 26 people were arrested by the CHP for a demonstration that took place on the Golden Gate Bridge here in San Francisco. Those 26 people were taken into custody on multiple misdemeanor charges as well as a single felony charge of conspiracy. Because they were booked on a felony charge, they now remain in the San Francisco County Jail. As a result of that custody status, the District Attorney's Office is required to file charges within 48 hours of their arrest. Unfortunately, due to the timing of their arrest yesterday, that charging decision has to be made by 4 p.m. today. At this time, we anticipate having to send the case back to the CHP for continued investigation. We have been in constant communication with CHP Marin regarding their investigation since these arrests were made. Once the investigation is complete, we will have to conduct an individualized assessment of the evidence to see what charges should be filed against which individuals that participated in the demonstration yesterday. Unfortunately, 48 hours, as you can imagine, and actually what turns out to be less than that, given the timing of the arrest, is not sufficient for this investigation to be completed by the California Highway Patrol, nor for my office to review evidence in order to make this charging decision. I want to make clear that San Francisco, as well as myself as the district attorney, support free speech. We support those who want to make sure that their First Amendment rights are observed and that their point of views are heard. But where we must draw the line is when acts of free speech endanger public safety. And just like we saw with the Bay Bridge protest 2 months ago, we now have a similar situation that took place on the Golden Gate Bridge yesterday. And we must make sure that public safety is observed in San Francisco, and that is what we are committed to doing. But at this time, we have to wait for this investigation to be completed before we can make the necessary charging decisions to go forward. And so at this time, I'll answer any questions that you have.
So basically that means that they're all going to be released.
So that does effectively mean that they will be released upon that happening, as we anticipate that we will not be able to make that decision at 4 p.m.
So let's not shout. Let's raise hands and stuff so we can see everybody. We'll start with you, then we'll go to Sergio, and then we'll go to Christian.
Thanks, Randy. Are any of the 78 that were arrested in November among the 26 arrested yesterday?
At this time, none of the people who were arrested on the Bay Bridge were arrested yesterday on the Golden Gate Bridge.
As part of the event on the Golden Gate Bridge, there were also several vehicles that were towed, and it turns out that people were chained to people sitting within those vehicles. Are those vehicles going to remain impounded as part of evidence as part of this conspiracy charge?
So we are still in communication with the California Highway Patrol about the status of evidence in their investigation, and so I don't have an answer for you on what will happen with those vehicles, but there will be discussion about that.
So two questions, kind of. One is wondering what the felony charges is. Are we talking about the false imprisonment, which the CHP had talked about yesterday, or the conspiracy, since this did appear to be a coordinated effort? And then I also don't understand how the clock works, because you said 48 hours, and by my clock they were arrested around 1 o'clock yesterday afternoon on the bridge. So to my math, that's about 26 hours right now.
Yes, so to your second question, I want to make sure that folks understand the way this works. It is very confusing. Because they were arrested at around 1 p.m., unfortunately, in order for us to make a decision on what would normally be the 48-hour clock, it would not be sufficient legally. And so it puts us having to make the decision today. I know that doesn't make a whole lot of sense to folks, but unfortunately, because they were arrested before 4 p.m. yesterday, it moves up the clock a bit.
Okay. And then the felony charges?
Yes.
What felony charges?
And so it's a felony conspiracy charge, a conspiracy to commit the handful of misdemeanors that they were booked on.
Is there a possibility that there may be some people What kind of things would you like the CHP to further investigate that would possibly satisfy that charge or any of the other charges that they're facing?
So first and foremost, we want them to pull any video that was taken of the demonstration, both from official cameras that are on the bridge, as well as there's a number of videos that have been posted to social media that bystanders and folks who were trapped on the bridge took. And so we want to make sure that we collect sufficient video evidence, that we have to be able to attribute specific conduct to specific individuals. So what role they played, that they were, one, present, that they were participating, and that they weren't simply an onlooker who happened to move forward into a crowded area. We need to be able to make sure that we can pinpoint who was doing what. When it comes to a conspiracy, that means that people are working in concert, that they are planning to commit a crime together. And so we, of course, we need them to gather any evidence to demonstrate that planning and that coordination.
I'm wondering how your Bay Bridge prosecution informs your prosecution now going forward for a similar kind of incident for those who are involved in the Golden Gate Bridge incident.
As always, we apply the facts to the law. We will never stray from that as a San Francisco District Attorney's Office. We look at conduct and we assess whether or not, based on the law on the books, whether somebody's conduct has risen to match what is required under the law. And so that is what we will continue to move forward on. In this particular instance, the CHP did make an arrest for this felony conspiracy charge, and so we are now tasked with evaluating whether or not their conduct rises to that level. And so that does require a certain amount of evidence for us to feel that we can meet that burden beyond a reasonable doubt. We certainly want to make clear in any situation, though, that when people violate the law, that there will be accountability.
Were you frustrated with the outcome of the 78?
And I know that there's been some confusion about the outcome of the 78 Bay Bridge protesters case. What I've heard recently, as recent as yesterday, are beliefs that we dismissed the charges in that case, or that we are who made an agreement to 5 hours of community service and a dismissal. And that's actually not true. We filed those charges. We maintained that we were moving forward with that case, but those misdemeanor charges were diversion eligible by statute. So the law actually makes those charges eligible for diversion. And so the judge in that case is who offered those defendants diversion. His diversionary offer was that they had to remain arrest-free for 3 months, and that they would have to complete 5 hours of community service in exchange for their cases being dismissed upon that 3-month mark. That was not an offer by the prosecution. That was an offer by the judge, which they accepted. And so we played no role in that agreement that was formed between the court and those defendants. Certainly, I know that people feel as though that is not sufficient accountability, and I do understand why people would feel that way. When we see these types of acts happen and the danger that they pose to the people who are on the bridge, who might be suffering medical emergencies, who might have significant things that they're trying to get to, people trying to get to medical appointments or procedures, we take that very seriously. If there was a natural disaster like an earthquake and somebody is on that bridge and trapped, that is a serious situation, a life-threatening situation. And so we do take that seriously. Unfortunately, I've learned in this job that there are many things that we don't control, and one of them is when the court decides to make that type of offer.
Is it fair to believe that these cases will turn out the same way?
It's a fair risk that if misdemeanors are all that's charged, that the court would similarly make that same offer to this group of defendants.
To your knowledge of the people who were arrested in Alameda County, do you know if those were involved in the 78? And as a follow-up, if there are any, does that affect their prior charge or agreement with the court?
So I do not have information about whether or not those arrested in Alameda County for the 880 demonstration have any overlap with our Bay Bridge 78. Should we find out that there is overlap, that any of the individuals from the Bay Bridge case were involved and arrested in that demonstration, it certainly is something that we would present to the court as evidence for why they should not get the benefit of the court's offer.
Wondering, it might be hard to say, is there because if these individuals are being released, there's presumably the investigation is still underway. Is it just as long as the investigation takes, or is there some statute that you have to meet it by some certain date or anything like that?
At that point, we are just up against the statute of limitations, which is, for misdemeanors is 1 year, for felonies is 2. And so, of course, it's not going to take that long. We do expect this to take at the very least several days, because again, it's not only the gathering of the evidence and the presentation to this office, but it's also my office's ability to review the evidence as it relates to 26 different suspects. And so that does take time.
Does this allow for a stronger case as you move forward in these prosecutions?
Certainly not trying to rush to judgment right now does allow for a stronger prosecution, because it allows for the investigating agency to provide us with more evidence than they otherwise would be on this short time frame. And so we always want to make sure that rather than rushing to just give people an answer right away, that we gather everything that we need to in order to build the strongest case and to make sure that the charges that we file are actually appropriate and will proceed through the court process without any issue.
Presumably the felony charge in this could lead, this gentleman here was asking about whether we might see a similar outcome if there was a felony prosecution on this for conspiracy. In other words, if they acted in concert with those in Oakland and other instances we saw across the nation, and it was this effort, we could see something different in terms of sentencing, because that could be, it's a wobbler, but it could be charged as a felony, yes?
They certainly are facing a potential felony charge right now. Again, as you may have seen in other cases, we still have the ability for a judge to make their own plea offer to a defendant. They would have to make an offer on that felony charge in order to sort of place a deal in front of the defendants that would require them to plead to that charge. But nevertheless, the court could still make that offer. The other risk is that the court has the power under the law to reduce a felony to a misdemeanor that's a wobbler. And so we would, of course, have to make sure that, again, we're presenting sufficient evidence so that the court understands why this charge should be a felony and not a misdemeanor, and why it should proceed that way.
You mentioned that there's the statute of limitations of a year for misdemeanor and 2 years for a felony. Since the conspiracy charge is the potential felony here and the rest are misdemeanors, how does that work? Is your statute a year or 2?
So I said that because in general, that would be the timeline we are on. This will proceed much faster than that. But certainly we would have to abide by what is the lowest amount of time, the least amount of time. And so we would always go with, the shortest window of time, which would be the misdemeanor, in order to file everything.
So we had the protest 2 months ago in the Bay Bridge, and we had the protest yesterday. There's been heavy criticism across the country. What would you say, I know you mentioned it message-wise, but what would you say to those people who may be planning another protest blocking a bridge once again?
I would say that look, I understand that people are passionate about issues that are going on in the world right now, and they need a venue and a vehicle for that expression. But they have to express their views in a way that is safe to the public. We are not going to allow people to endanger other members of the community and of our society in order to express those views. When you cross that line, we have to have accountability, and we will in San Francisco have accountability when people cross the line when it comes to free speech that puts people in danger and in physical harm. And so I would just say we are a city that embraces your First Amendment rights. We make places like the Civic Center and in front of City Hall, and we even make possible marches through our streets downtown with the help of the police to make sure that those who are demonstrating are safe and that the overall public is safe. Use those forums because, again, we are a city that will provide those forums that are safe and that are lawful. But when you cross the line of the law, we do have to do our jobs.
Is there any concern that people who are stuck in these events as they continue will begin losing their patience, thereby putting some of these protesters in danger themselves?
I think we've already seen that across the country. I mean, we're not the only place where these demonstrations are happening, and we have seen those who have been trapped on these roadways get out of their cars and start to become violent with the demonstrators, and that's something that we don't want. We don't want to have a system of vigilante justice. We don't want to have anyone get hurt, not a demonstrator nor someone who's been trapped, and we don't want to put people in a position where they feel that that's their only recourse. We have to allow, again, for people to have safe passage to be able to move on with their daily activities while still affording people the right to free speech. But we certainly don't want to, as a government and as law enforcement, be derelict in our duties in a way that puts people in that position.
Do you worry that people are critical of you and of the law enforcement agencies for potentially doing that?
I certainly have received a fair amount of criticism for charging the individuals in the Bay Bridge case. I expect to receive the same criticism here if we do file charges. But again, I have a job to do, and that's to protect the public, and it's something that I take seriously. This isn't about taking a political position on any particular issue. This isn't being for one side or against another. This is simply making sure that I do my job to enforce the laws here and to keep people safe. And again, there are lawful, safe mechanisms for people to provide their expression on these issues, and I'm all for that. But again, when you block people on a space like a bridge where they cannot get to what they need to do, where they can't have access to emergency services if they need it, restrooms, all sorts of things, that's just taking it a step too far, and it does then involve law enforcement. So I just have one more thing that I'd like to say, which is this is an active and open investigation. Anyone who was falsely imprisoned on the Golden Gate Bridge on April 15th, 2024 is urged to contact the California Highway Patrol at 415-924-1105 or via email at chpmarin@chp.ca.gov. and provide them with a statement detailing what happened to you and with contact information so that you can be reached as a victim. You may be entitled to restitution and have other victims' rights guaranteed under Marcy's law.